Good morning, everyone. My name's Nick Leon. I'm a Senior Associate in the Workplace Law and Culture team here at Bartier Perry. This morning we're doing a presentation called Terminations and Settlements, and it's a panel discussion. Before I introduce the panel, I'll just introduce the webcast. We are broadcasting live this morning. In terms of the webcast, below me, anyone who's on the webcast, there's a speech bubble. That's where you ask a question. If you're on the webcast, feel free to ask the questions as you go. For everyone in the room, we'll take questions at the end, but I'll have a list of questions from the webcast people as well, which I'll throw in at certain times. As I say, my panel. Today we've got Darren Gardner. Darren Gardner is a partner here in the Workplace Law and Culture team. He's a trusted advisor to lots of people in this room, government departments, corporations, and the like. And also we have Robert Migliori, who's from Activate, which is a workplace health provider. Robert's got 25 years in assisting workplaces in achieving lots of different outcomes in terms of their people and how their people run. Now, how this presentation is going to go is I'm going to attempt to moderate these two gentlemen. What we're going to talk about today is we're going to consider the benefit of work to the individual who's working, also to the organisation who gets the benefit of that employee, but also understanding there's a tension sometimes between when the person and the benefits that they derive from work don't align with the organisation's needs, and there might be the need to move that person on, and how we go about doing that. Talking about communicating and having those discussions, documenting those discussions, and then considering the health and welfare of the people throughout that process. So the evidence is pretty clear. Aside from the moments when we're lying in bed and don't actually want to get up to go to work, generally speaking, work is good for you and the absence of work is not good for you. And in terms of what people derive from work, it's a range of different things. It's not just financial security, although that might be primarily why people do it. It's the sense of inclusion, the sense of community, being part of a footy tipping competition. It's the contribution to society and their families. It's giving structures to days and weeks. It's a range of different things. It's even, and the evidence shows this, the decrease in risky behaviours, as in people who are at work seem to be drinking less and gambling less. So work contributes in a range of different ways to the individual. Obviously, the work that the person provides also contributes to the organisation. And this benefit of work is recognised in the law. It's recognised in terms of reinstatement being the primary remedy for unfair dismissal. And in a famous case of Quinn in 2010, the judge said this about the benefits of work. And I'll just read it to you because it's important. There is now greater recognition that employment is important to an employee, not simply because it provides economic sustenance. Workplaces are hubs of important human exchanges which are vital to the well-being of individual workers. Work provides employees with purpose, dignity, pride, enjoyment, social acceptance, and many social connections. And his honour continues. But what happens when work and the benefits to the workplace no longer coexist? Work's obviously a two-way street, but there are some times when just because employment is good for an employee's health doesn't mean that they're good for the business's health. And when that happens, what we have is a tension between the individual's needs, the organisation's needs, but also the impacts that it causes to colleagues. There might be colleagues who would be happy that this person is moving on because that person hasn't been pulling their weight, or there are other problems or dysfunction in the team. There might be people who are disappointed because they're losing a colleague and a friend who's been in the workplace for a long time. And in between all that, there are often HR professionals who are forced to juggle all of these things. And I might just go to you, Robert, in terms of where HR fits in.
It's probably not a good place to start the life of Brian, but or for those unfamiliar with that, this little clip, we often are helping managers resolve some of the conflicts in the workplace, and what we wanted to do today in this discussion was explore some of the challenges that you as HR professionals have, as supervisors, managers, even directors have in that interface. We actually have to have that difficult conversation and move a person on. So we really want this discussion to open up because it's one of those things that no one ever really talks about. We're often at the coalface helping people make those difficult decisions, and the lawyers are there strategising about how the termination will take effect and take place. But the human elements of all that are some of the things we want to talk about today. So we often look at, for example, Pontius Pilate as the archetypal judicious person who had to make a call about someone he knew nothing about. And this is often a typical situation for, particularly for HR managers, having to look at a termination for someone they know very little about, and often having to have what is essentially a very complex discussion. The personality traits that we often explore in this realm are the narcissistic personality type, the conscientious, obsessional, the emotionally immature. These are the personality types that come to the fore at the coalface when you're having these difficult discussions.
So what we know, and most anyone who's been to one of our presentations, is when you're deciding to terminate someone's employment, or you're looking at performance management or the course that you're adopting more generally, and I'll throw to Darren in a second just to talk about a couple of these things, but we try and figure out what the real reason is, because the reason for the approach that you're adopting often drives the approach that you're adopting. So whether it's capability, performance or misconduct. What we've introduced today, I suppose, is that human element, the fourth pillar, to suggest that in all of those things, perhaps we should consider the role of the people and the impacts that these kinds of decisions have on the people. Now, Darren, in terms of getting on the right track.
Well, it's very important, and personality is often something that's not considered or deliberately avoided, in that that could be the path down the track of claimed disability or some other problem that's not within your realm, but it often does, as Robert just mentioned, it often does have a driving force and motivation behind what's going on in the workplace, and others in the workplace have picked up on it a long time ago. It was they knew that it was that cranky baby face that was going to come out eventually. But in terms of understanding capability, performance or misconduct, it's very important to understand which path you're heading down, because there'll be an entirely different process for each, and often what we find is that something that is described as misconduct is really performance, or something that is described as performance is really just a capability that hasn't yet been properly identified for education, training, skills development, or there's been a presumption made that the person lacks those inherent capabilities, therefore they're out, when in fact, and what we'll do in this discussion is explore how some of those fundamental decisions that are made about whether it's capability, performance or misconduct can have dramatic consequences, and even personality can have dramatic consequences in the end in terms of, say, a dismissal case that you never thought should have happened, but it did because you took a path and you just kept going down it.
And that's really critical. For those of you on the webcast, we will share the slides with you after the event, so you don't have to worry about that. The reason that you want to understand which path that you're going on and what is actually happening so you can engage with the person and have those discussions is because recognising the real reason for the decision is really important. And there are real reasons, there are the right reasons, but there are also the wrong reasons, aren't there, Darren?
Well, and this term, real reason, actually resonates in two different settings in employment law. So it's often the indicator and defence to discrimination claims, in that what the case law examines is whether or not the real reason, which is what judges have called it, involved a characteristic generally appertaining to a person or a discrimination ground that's protected, or it's not. And it's the same test that applies in general protections and adverse action too. What is the real reason for taking disciplinary or dismissal conduct? Is it the workplace right that the person has asserted, or do you have a genuine performance capability or misconduct reason? And so, and if you've chosen the wrong path, you'll never make it out, because you've already confused the path that you've taken as being, say, performance instead of capability, for example. Or, even worse, it's actually the person's personality, and it's a diagnosed personality disorder that is the real reason, and then you've got a discrimination case.
So understanding, identifying the real reason is going to be critical, because what the real reason is will drive the process. But when we talk about these kinds of things, and I think we can group all of these processes together, one of the things that we're seeing, and we see this a lot, is the importance of communicating, actually talking to the person about the reasons, and expressing those reasons in a way that are understood, and listening to what the person has to say. There is often quite a big gap between what we think and what we think is being expressed as opposed to what's being heard and what's being understood, because there are a lot of filters in between those, there are a lot of perspectives and those kinds of things. Understanding that those barriers are there is really important, because, well, what we say is if you're going to have a termination, you should have the meeting. Dismissal by terminating, dismissal by text message is not ideal. It's hardly ever appropriate. I mean, there are some circumstances, Darren, where it might be appropriate.
Yeah, so this quote, which has been cleverly put in a text message, is one of those, well, it's one that's got a bit of airplay in the press as a gutless abrogation of an employer's obligation to act reasonably and decently. There's been other cases where it's been described as gutless, outrageous, including one text message sent the day after Christmas, dismissing someone. The real problem with, it actually has been identified, including in that case I just mentioned, the after Christmas case, that there actually could be circumstances where text messaging might be appropriate, but those occasions are very rare, and it would be a last resort. That is, you've got, and the decision, which was in, it's the decision of Sokolovich and Modesty Fashion, which went on appeal but remained undisturbed on appeal, was that, I mean, if you've got a situation where you've got some genuine concerns about aggression or violence, and having a meeting would pose a genuine risk to you or others in the meeting, and it's accepted that text messaging was a form of communication that pre-existed with that employee, for example, coming in for shifts and so on, it might be appropriate. Or you've already made up your mind that you're dealing with a serious misconduct issue and it's an instant dismissal, and you've taken the punt that the reason you've chosen is serious misconduct and it's instant dismissal. But you run the risk. The real problem with any of these methods of communication, which are not face-to-face, is that it's a one-way form of communication, and you're running the real risk of not being able to prove that the person had an opportunity to respond. We'll explain in a moment how that can come home to roost, in the sense of you're also missing out on an important conversation that may need to be had, which is not just to sort of provide the litigation shield you need to say, well, we extended procedural fairness. There could be something materially relevant, factually, that you need to know before you make that final decision, which could impact on a whole range of things, not just relevant to the business, but to the person themselves and risks that they have in their own life.
So what we've got there is the procedural fairness aspect, the fairness to the employee in terms of the opportunity to respond, the opportunity to tell you why the decision is incorrect, or to voice concerns about the decision. But we also have the human aspect and the human interaction that comes from having the meeting. The quote-unquote opportunity to see whether or not there's another way forward besides dismissal. That opportunity is lost if you communicate by text message, because you don't actually engage in the discussion. You don't talk to the person about why they are not necessarily a good fit for your business anymore, or you don't really get the opportunity to assist them to realise that the fit no longer works. So yes, there's the procedural aspect and the courts reflect that, but from a business or an organisation, there's also an opportunity to engage with the person to see if there's a win-win, or if there's another way of doing things, or if there's another opportunity to resolve this in a different way. And that really comes together in terms of settlements and settlement discussions, and having those settlement discussions. If you don't have the meeting, it's quite difficult to have those discussions.
Sorry, Nick, I was just jumping in here because this is a perfect example of where in a Fair Work Commission unfair dismissal case, not having the meeting was a very bad idea. Here we had, believe it or not, and there's a few of these cases, but this was a solicitor who worked at a law firm, and so not a good start. But, and she had the need, and wasn't telling people why, to leave early some days, sometimes at 3, sometimes at 2:30, and she actually did have someone mention to her, look, if you need to head out somewhere, just let us know as partners, because we need to know where you are. However, she didn't follow that advice, and Ms. King, on one particular day, headed off a bit earlier than usual at 3 o'clock, I think it was, and when she came back, there was already a letter for her saying, well, that's it, we've had enough of this and you didn't tell us, and even though she'd passed her probation, there hadn't been any other issues, that was reason for dismissal. The problem was, she quickly, after that decision had been communicated, she let it be known that the reason she had to be leaving early was out of embarrassment, and that was because she was attending to court matters involving domestic violence involving her former partner. And so the decision had already been made, and remarkably the law firm didn't even engage in a further discussion with her about that, and challenged it out in unfair dismissal proceedings and lost, of course, but it was found to be unfair in the sense that, although it was a valid reason, it was found, interestingly enough, to have reminded her that the partners needed to know when she was out of the office and for how long. It was harsh to dismiss in the circumstances of domestic violence. And unfortunately, this is a common issue, and it's been recognised even in the Fair Work Act now as a grounds for seeking leave. But there are occasions where even professionals, such as solicitors, might have a reason that is embarrassing to disclose, or may have a reluctance to disclose, but it's still a valid reason to be leaving duties.
Now, there are other common issues that arrive in terms of having these discussions. I won't go through all of those. They're in your slide pack. We've put refusing to meet at the very top. Meeting at the wrong time with the wrong people. Darren, did you want to talk about who the wrong people are? And
I'll mention, it was actually something I worked on with you this week, you might recall, where we had, or last week, where our client was refusing to meet with the husband of a employee because, and it was quite reasonable in my view, in that husband in the past during a performance discussion had become aggressive and violent and threatened the HR manager personally, to the extent that an order was obtained from court to prevent him from approaching their business anymore. But when the time came for a further disciplinary interview, it was quite reasonable to say, no, your husband is not welcome, and in fact, he's lawfully not allowed to come to our premises. So there are occasions where you should be setting, I mean, that's an extreme example, but there'd be occasions where, again, for health and safety reasons, or simply that you just are not comfortable with a particular support person, you'd be quite entitled to say, no, I don't wish to meet with that person, provided you've got a good reason, and you're free to choose somebody else, but I'm not prepared to meet with that person on our property.
Further to that, we had a situation recently where one of our psychologists was asked to perform a psychological assessment for a person who had demonstrated some concerning behaviours in the workplace, and when she went to interview him, during the interview he told her that he was going to actually kill his ex-partner and kidnap her daughter. So in that first meeting, he was very aggressive towards her as well, and that of course precipitated an event where the police were involved in apprehending him and taking him to a psychiatric facility for assessment. And the interesting thing about all of this is that on this point about meeting the wrong people at the wrong time, the business actually knew that this had occurred previously, so for some strange reason this fellow only wanted to meet with female psychologists, and that was a stipulation that he made, and on two other occasions he had made the exact same threat, and the business knew about this but had failed to share it with us. So they either didn't see it as severe enough to share, so we weren't in a position to adequately risk assess the carrying out of this psychological assessment. And further to that, he then made death threats towards our psychologist that endured 6 weeks and beyond that first assessment. So we weren't able to carry out the assessment. We then had to arrange for him to be psychiatrically assessed by one of our psychiatrists, and we had to arrange for security to be present during that assessment. So I think it's very critical that we take things very seriously when people say them, but at the same time we do it in a manner that is always assessing the risk and when and how these meetings are carried out.
So the scene that we've got right now is you've gone through your process, you've investigated, you've put allegations to someone, you've formed a view about those allegations, and you've decided to terminate that person's employment, and you're having that meeting about that, and you're conveying that and the reasons for that, and the person might not agree with you, but everyone understands. The question we've got for you is, now that you're here, should you have the off-the-record chat? What is the off-the-record chat? Does anyone have a view about whether or not there should be an off-the-record chat? Well, maybe it's just a show of hands in the room. Does anyone think that there should be an off-the-record chat? Some hands. Anyone think that there shouldn't be an off-the-record chat? Ooh, a lot of hands.
There's no right or wrong answer to that question. However, I think it's more that is there such thing as an off-the-record chat is the question, and certainly at law, it's possible to have certain discussions that will not be admissible in legal proceedings. However, it's important that it falls within how the Evidence Act describes without prejudice discussions. So there needs to be a dispute. So it needs to be a disagreement between you and the employee to start with. So that could be simple. It could be that you have certain allegations of misconduct or performance, they deny it. You've got a problem though if they're in total agreement with you. But they might have a disagreement with you about proposed dismissal action or some other action. But so long as you've got an agreement to disagree, then you can safely put to them, well look, there are two ways to proceed from here. If you're prepared to have a without prejudice discussion, that means what we say during that discussion is, you could say off the record, but those words don't have any special meaning, but they're off the record without prejudice, cannot be used against each other in proceedings. Do you agree to that? If the employer says, no, I don't agree to it, you stop. But if they say, yes, I agree to that, then you've got a protected discussion that's off the record.
I think one of the issues with the off-the-record chat is that typically either party is attached to an outcome. So if you're attached to an outcome, then it's really not an off-the-record chat. And I can give you an example of one where I was involved in recently. The national HR manager had been self-harming and had been coming to the workplace with cuts on her face. It was quite a dramatic self-harming pattern of behaviour that had emerged, and some of her colleagues had said they were very concerned about her. In the end, she ended up being placed into a psychiatric facility, and in the wake of a 6-week stay there, we were attempting to put a stay-at-work plan together, and we were asked to have an off-the-record chat with the CEO and ourselves present and this national HR manager. The trouble with the off-the-record chat was that the CEO had already been told by her board that they had to get rid of her. So the complexion of the off-the-record chat was that we were trying to get her to essentially fall on the sword and say, this job is just too hard for you, given that you are still in the recovery phase. And I think this is an important point, and that is that if there is an off-the-record chat, or if you're thinking about having one, then you really have to be mindful about not being attached to an outcome. And in the end there, what actually happened was that the last point, she then commenced legal proceedings against them to say that she was being forced to resign in that meeting. So there were various things that the CEO said in that meeting that made it plain and simple for her to take the view that they wanted her out of the business. And this is the problem with the off-the-record chat, at least from our experience in this particular case.
So then, if the off-the-record, I mean, that's an option, but there are other forms of assisted realisation that it's time to move on. Some of those are just discussions. What are the other options?
Well, apart from being a lawyer, I'm also an accredited mediator, and mediation or other forms of dispute resolution are actually they're an extra protection, an extra protective way of having these discussions. And so certainly Robert's example might seem extreme, but there's plenty of cases where you thought you had a safe, without prejudice discussion, and you end up having that discussion, particularly with self-represented people who can't get lawyers, who then drop it into an affidavit and say, I was forced into this discussion. So where you don't have total confidence that the discussion you're about to have will be off the record, you might wish to, but you still want to avail yourself of the opportunity of a neater way of resolving matters. That is, rather than having to rely on volumes of evidence and an investigation that's going to take a lot of time and money, is there another way of getting to the same outcome? A mediation, for example, might be the way to do it. the benefit of a mediation is if you've got it one set up with an independent mediator who has a confidentiality agreement and a mediation agreement, once you have all the parties, it's voluntary of course, but once you have them signing those documents, it will be very, very difficult for anyone to then try and use discussions in mediation in any proceedings. It would have to be in an extreme case where they'd be given leave to do so. So, and I've used that quite successfully in a number of matters where it was obvious that having any process that involved putting evidence to somebody would never change their mind. They were steadfast in their belief that they were right and you were wrong, and so we needed the assistance of a professional facilitator, which was a mediator with a lot of experience, who helped that person realise, with the benefit of their wife being present too, mind you, that it was time to move on. And actually it was the wife who was instrumental in that decision, because she'd sat there for 8 hours listening to her husband rabbit on. She called a time out, came back and then said, I've been listening to my husband all day and haven't said a word. Now I'm about to say what has to be done. So they'd made a family decision which involved them moving back to where they came from. And she actually wasn't convinced by anything her husband had said about what was going on at work. But that was important, and it allowed a decision to be made that was confidential and agreed.
Thank you. Now, I might circle back to Robert in terms of your examples of being an advisor at the point when we get to the case studies. I think that might be an opportunity to talk about how you've been involved in those kinds of things. Assisted transition can be very simple, and you've all probably been involved in assisted transitions. We've all had cases of perhaps the person who doesn't come to work. And they're great when they're there, but they just don't come to work. And sometimes you just have that discussion about, well, you'll be a great employee somewhere, sometime, but just not here, not now. It just can't work because you don't come to work. It can be as simple as that. It can be more complicated. In terms of assisted transition, we're really interested to whether or not you think there's a duty from employers to think about their employees after they leave employment. Does anyone think that there should be an ongoing obligation to think about the wellness of your employees? It's a really interesting point, because lots of us put on our shields when we come to work. We come in, we do our work, especially HR professionals. They do what needs to be done. But the idea of the mental health risks in the workplace and how those impact not only when the person goes home, but when they go home and never come back to this workplace, are really important considerations that we can think about. Robert, do you have any views about where the obligation of the employer ends?
It's a very complex area, and obviously, particularly in the lead up to these terminations, it's a very dramatic process, and we're often involved in trying to quieten that drama down. But as you're leading up to the termination in the day, then it all happens and everyone breathes that sigh of relief. But there's still a sense that this person who's left the business was an adversary, and therefore I don't really have anything or want to have anything to do with them anymore. And one of the things we wanted to explore today is whether we're really mindful of the indignity of all of that. And we talk about workplace culture and we talk about workplace communities, and even Nick's introductory piece about the importance of this connectedness that we have in the workplace. But then this person leaves and they're gone forever. And you might hear about them in the lunchroom that, oh, I heard from Mike, he's now working here, or he hasn't found a job yet. And there's very little that most people do to reconnect with that person, so to have an ongoing dialogue at any level with that person. And I don't necessarily have a position on that, but I think it's something that is important to consider when you're going through these processes, that how will you continue to have a lifeline to this person if that's something that the organisation wants to have and is part of their ethos and their values.
I was just about to sort of be a little bit controversial and say the Court of Appeal in Pioneer Construction Materials and Thomas Milsom looked at an argument that was there a duty of care to provide employee counsellings in a dismissal situation, and the answer was no. However, it was recognised it was a good risk mitigation strategy. So it's not a duty of care, but it's probably more so that you have it in place to minimise risk to your business and also to the employee.
Yeah, and that's the case as well. There's a case called Page in the state of New South Wales, and in Page, that question arose as well. The question was, did an employer have a duty to the mental health of their employees during an investigation that ultimately led to dismissal? And the Court of Appeal in New South Wales said no, there's no such duty. But again, from a risk mitigation strategy, it would be important to take those things into consideration. It might not change what you want to do, but it's important to be mindful about that because, you know, Darren often says, you know, we're a workplace team, we've got to walk the talk. And I'm sure that's the case for HR practitioners. We do want to walk the talk in terms of what we do and how we treat people. We've got a couple of case studies here. We've got 3 case studies. We've probably got time for 2. Perhaps I'll give you a choice. We've got the aggressive worker, the employee with psychiatric conditions, and the older employee with fears for the future. Has anyone got a view about that? I'm quite partial to the aggressive worker, but that's just me. Perhaps we'll start with the aggressive worker.
This case came about, interestingly, both our firms are involved in this particular matter, and James Matson, who's here in the room, tapped me on the shoulder and asked me if I would sit in on essentially what was going to be a show cause to this particular individual. Now, this individual worked for a government organisation. He had been off work for 6 months on the basis that that organisation didn't know what to do with this guy. He'd been extremely aggressive. He'd made threats towards his manager and other colleagues, and there was certainly substantial evidence that that they were going to terminate this guy, and James had prepared a 3-page show cause letter that was deadly. On the back of that, I think one thing that they were very mindful of was how was this guy going to react when the letter was delivered to him, and he asked me to be there in the wake of that letter. So the letter was delivered to him. The HR managers quickly scurried out of the room, and I was brought in by shoulder and ear, and the union organiser was in the room with this particular fellow, and I came in and softly introduced myself, and the union delegate, the union organiser didn't say a word the entire time. But what happened was I was able to somehow build a rapport with this fellow, and we talked for about an hour and 45 minutes, and he told me his whole story. And the business didn't know any of this. They didn't know any of his backstory. He had a very checkered past. He'd had a motorcycle accident when he was 15, and as a result of that accident I could see, because I have a brain injury background from my studies, I could see that perhaps this fellow's aggression was due to a traumatic brain injury. And he described what happened after the motorcycle accident, that he'd been in hospital and he'd been on a respirator. Perhaps there may have been other comorbid issues going on for this guy that precipitated these acts of aggression in the workplace. The scary thing that happened was that he actually admitted that he had just been charged with a string of offences, and the sentencing hearing was in 2 days from this meeting that I had. So he actually ended up going to jail. So it was the charges were pedophilia. They were very significant charges. The aggression that he had towards others in the workplace probably had a lot to do with this sense of injustice he had about these pedophilia charges, which he rejected. And so you can see how this aggression had emerged, and I started to see a real behavioural pattern of this guy really unpacking the issues that he had in his life. Look, in the end, it was more like a counselling session. So here's the counsellor in me coming out. It was more like a counselling session. It was a very, if I could use the word loosely, it was a very healing discussion for him. He thanked me, he gave me a hug at the end. He had his tricep was probably as big as my chest, and he had tattoos all over himself. Thanks, James, for putting me in the room with him. And but look, it was a great meeting, even though it was a very sad outcome for him. He felt he finally got to tell his story. So this is something we often don't do because we're so worked up about having to carry out this really difficult conversation. We're not listening to the backstory, and I gave the guy a chance to do that. And in the end, we got a good outcome for the business.
So we might now just talk about the older employee with ears for future employment.
This is a segment of the workforce that is growing and becoming more prominent in the sense of, and there's a case that I recall which was an unfair dismissal case involved. It's called Anderson and Teese. And you might recall it was a case where the employee there was 65 years old, and all of a sudden he started sharing emails that, it's usually the older workers who take up this sort of sharing of emails that they've obtained from some relative overseas or something. They think it's hilarious, and then send it around the office expecting everyone to share the joke. And he sort of was doing that with a few sort of strange emails to begin with, and then it became a little bit more radical where there were emails that were expressing views about fundamentalism and people of the Muslim faith, and that's where there had to be a discussion with this bloke to say, well, look, this isn't appropriate anymore. But what was interesting was that this guy just didn't understand it. He just said, well, look, I find that I'm entitled to express my views. I don't believe in this religion, and I have these views that I want to share with people. I've got a right to do this. So it was quite a confronting discussion with the HR people who said, well, this is contrary to our corporate values. And his response was, well, I don't care. And of course that didn't go well for him, but he was dismissed. However, interestingly, he actually succeeded in his unfair dismissal case because I think what wasn't taken into account was his age, and they must have realised in preparing for the case that this was also the older bloke who never went to any of the training sessions, and so although they had fantastic training records of all of the IT training and appropriate code of conduct training, this was the older guy that nobody noticed, didn't turn up, and there was no evidence that he'd ever been trained. So part of his defence actually succeeded in that he said, well, look, nobody's ever explained this corporate values sort of thing to me. I've got my own values, and this is what they are. Interestingly, the Commissioner said, well, we do live in a country where it's free to express those views, and it's not illegal to do so. However, that wasn't the reason that the dismissal was found to be harsh. What was the reason was that he was 65 years of age. So when you read these unfair dismissal cases, there's the final ground, which is any other considerations. So the company actually won on the ground that it breached their code of conduct and appropriate behaviours policy, but they hadn't taken into account his age and the impact it would have on his life. So that's what's interesting about the case, apart from this man's very steadfast views on his right to freedom of speech, which didn't save him, but what did save him was his age and the impact that it would have. So if they'd actually taken an extra step of talking to him about what his... I mean, this is where it's dangerous territory too, because once you have this discussion about, well, what's your future like outside of work, he might have been very happy having access to the IT system and sharing emails on the employer's time, I don't know. But it can be a reason, and then there's actually a string of these cases where age itself, and it's not that surprising because when you come to see us, we ask you, well, what's the age of this person, how long they've been with you, what's their history like in terms of prior warnings. They're all simple questions we ask because they're the usual indicators of possible unfairness. But sometimes age on its own can be enough.
Nick, are we allowed to talk about the psychiatric
Yes,
one?
we are.
I just want to share this little story because it's something that's relevant to all of us, and psychiatric conditions are usually what our two firms are often involved in trying to manage for employers. This particular incident that I want to share is one that involved a law firm. So we carry out the employee assistance counselling for this law firm, and the HR manager said, we're having a problem with one of our senior associates. Will one of your psychologists see her? So our psychologist saw her for 3 sessions, and obviously that remained extremely confidential, that whole discussion. So we weren't privy to what had occurred in those sessions, as in the employer wasn't privy to what was going on with the psychologist and the counsellor. But it all transpired that what had happened was this particular senior associate had presented with a medical certificate and an accompanying letter from her neurologist to say that she had narcolepsy. So is everyone familiar with that condition? So narcolepsy is a condition that essentially impacts on one's ability to stay awake. So they can have these spontaneous, if you like, moments of sleepiness, and they often can be quite dangerous when they happen. So she'd presented with this certificate and an accompanying letter from the neurologist, and the HR manager presented that to us and said, look, we've got this condition of narcolepsy, we're waiting for the neurologist to write to us, and the letter just didn't look kosher. You know when you look at something and your intuition tells you something isn't quite right about this letter? And I remember saying to the HR manager, I don't think this letter's kosher, and she said, it's impossible. It's impossible that it wouldn't be kosher. And I said, well, I'm going to call the surgery, and she was quite concerned that I was breaching privacy, and I have to admit that I was. I called the surgery, and of course the phone number at the top of the letterhead was actually a fax number. So that was the first sign that something wasn't right. I then called the real surgery and explained that I'd had a letter, and she said, will you fax it to us? So I faxed the letter, and of course 2 minutes later the surgeon calls me on my mobile to say, this is a forged letter. I didn't write this letter. This person has fabricated this certificate. So we then had to confront this person, and we did so in a very careful way. We were mindful that something was going wrong with her at the psychiatric level. We were able to intercept some of her emails, her work emails, and she was having, it turns out, an affair with a fellow who was an Ayurvedic massage therapist who had persuaded her to come off her psychotropic medication. So she had been on quite a very good regimen. She was able to function at a very, very high level as a senior associate in a top law firm. And what had happened was, in the interest of her going down this more naturopathic path, she'd come off her medication without proper supervision, and then you'd seen this escalation of behaviours. In the end, we confronted her with this material, that we had a doctor's letter supporting that this was a fabricated letter, and she ended up shortly after that telling our psychologist, who was her support person, that she wanted to commit suicide, and she had a plan, and she was actually going to do it that evening. So we had to, in our rooms, call the police, and then the ambulance came. She refused to go to the hospital. Eventually she did go to the hospital, and she was in hospital for 4 days, and her mother flew from Brisbane, collected her, and she went into recovery. We managed to continue having contact with her, and we later learnt that she actually did resume work with another law firm. She'd gone back to her medications, and she was able to lead a normal life again. So I think it's an important case study to remember that people can get back on the horse. They need to have the right supervision, they need to have the right medication, and sometimes these episodic illnesses can be so dramatic and so challenging, but with the right support, people can actually resume a normal working life.
I'm just mindful of the time. We might talk briefly about evidencing an agreed exit in terms of the formalities and issues that come from evidencing an agreed exit. There are a lot there. There are lots of different things to think about. Darren, maybe there's just one or two that you might like to talk about, just to draw attention. This is an area that when we broke it down, and it is a bit of a spoiler, we thought that this was a presentation on its own, this one slide, and to go through the formalities and the issues. And I've seen some questions talking about, you know, when you put together a deed, what are the traps and tricks. So if that's a presentation that you might like to come to, then drop us a line and let us know, because we thought that this, in today's context, might only be a couple of minutes, but it could benefit from a longer treatment moving forward.
Well, the one that I'll choose is the dangers of offering an ex gratia payment during a discussion, in that it's something that is often offered probably as a last-ditch desperate attempt to get somebody to move on, but it's not well understood what it means. And the actual term ex gratia, although it sort of has its roots in the finance industry and it's accepted as being something that's regularly sort of available as a special bonus, or it's actually a gift. It's a payment without obligation. So when you use those words, be mindful that although it's not commonly understood exactly what it means, strictly it does mean it's a gift or without obligation. So there have been decisions where those words have been used in a settlement discussion or a transition to moving on discussion, which was an inducement for that person to go on. Now, what the difficulty you have, particularly if it's a long-serving employee, is if, for example, they've got very valuable accrued service entitlements, they are definitely entitled to those separate to any additional payment you make, but it also could lead to a misunderstanding as to what they're getting it for. And a strict interpretation, and there has been a decision which is, it's an old case of Thomas Cook and Pathojon in 1996 where this actually happened, and what was said to be the ex gratia payment was the only payment, and it was subject to a deed, and so the deed was put together. That amount was described as an ex gratia payment, and the employer said, wait a minute, I'm entitled to all my other entitlements as well. And the employer said, oh no, that's not what we understood it to be. And unfortunately it went before a judge in the State Industrial Relations Commission who said, sorry, it's a payment without obligation, and in fact you don't even need a deed to receive it. So, because there's no obligation, there's no strings attached. That's the danger in using that description for that word, but it's not often understood.
So we're close to the end, and I wanted to have a chance for some questions. There are some takeaways from today's session. The first takeaway is, even when we think we know exactly what's going on, sometimes we don't, and it's worthwhile having the meeting and asking the question and drilling down into those things a little bit. The termination meeting is a critical opportunity for both the employer and the employee. Being flexible in your approach means that you can adjust to the needs of the employee, taking into account that their personality their needs and ultimately the needs of the business. We hear lots from employers who feel obliged to help people after they've moved on, and that's really good in terms of being flexible in their approach. When we have the meeting, at the very least, what we know are the risks that we face when we proceed. So if not for anything else, to properly understand where your risks are and the areas that are going to be taken into account, that's the benefit. Carefully document the agreement the right way, using the right terms. And as always for HR professionals, being resilient when putting on your suit of armour and going out to battle. Are there any questions for us?
In regards to your older employee, what tactics can employers use if a person genuinely does need to move on, but age is a barrier? Because you can't change their age.
No, you can't, and often you can't change their attitude either, and that you can't teach an old dog new tricks sometimes. Interestingly, the law in this area recognises that in certain industries and occupations there's an accepted retirement age. So even though technically you can't force somebody to resign or retire because of their age, in industries or professions where it's sort of accepted, and it may be because of superannuation or other reasons. So what is often helpful is to suggest to the person, well, look, have you spoken recently to your tax advisor or accountant about the best time financially to be leaving? Because often they don't realise that staying on too long could be no better, and it could be worse, depending on their superannuation scheme, to be sticking around. That's one tactic. Another one could be that, and this is a very difficult area, but sometimes the reason for wanting there to be fresh talent in a business is because there should be engendered in the business the desire to, what I call stewardship, to foster stewardship, encourage the older talent to pass on their experience and wisdom to the younger ones. So another kind of strategy is to be actively involving them in that knowledge and skills transfer, on the understanding that once the job is completed, then they've agreed to a transition out of the business because that was the most important job they had to do in terms of stewardship.
Just to follow on from that point, Summit Care, which is an aged care provider, told me a great story recently about what they'd done to help people who were having difficulty with retiring, and they brought their retirement professionals into the business to assist people in the planning of their retirement. So the phenomenon they have is they've got older workers in a very older environment, so they don't feel old. They don't feel old at all, and this is the thing that they're like, well, this person's way past retirement age, but they're looking after people that are 20 years older than them. So they had a very proactive strategy that involved a retirement advisory firm, offer free assisted retirement planning, and they also had a range of other issues, counsellors involved in helping them look at a vocational activity that might happen in the wake of their retirement.
Are there any other questions? I'm mindful of the time and I'm sure everyone's desperate to get back to work.
There may have been, there were a lot of tiles on that settling and documenting sort of arrangements to leave, but is there anyone who'd like to ask any of those questions? Or, I've got...
I'll just be loud. You said don't use ex gratia. What do you use instead if you're describing a payment?
Often it's good just to call it a settlement payment or an agreed payment. Particularly if it's particularly important too if you use an agreement form. So there's a number of ways to document things. If it's by way of deed, then consideration is not required. but an agreement form consideration is an important ingredient of a binding settlement agreement. And so it's important to actually describe it as consideration. So it's an agreed payment in exchange for these releases or these benefits. So that's why it's particularly important to give it the right label, because otherwise if it's a gift, no strings attached, not consideration.
When you have an employee that, if you maybe use, for example, your HR example where you had the lady that was harming herself, when is an employer under an obligation to advise workers' comp, or can you just handle the hoop jumping to eventually let the employee go without workers' comp becoming involved in the return to work?
Well, I mean, Darren's probably the best person to ask the question about obligations with respect to workers' comp. But typically what happens in these situations is that there's often two strategies. So there's the psychiatric condition and whether that's a compensable condition or not. And then there's the whole dismissal or termination. And the difficulty with matters like this is that you've got the person that's in your duty of care that you have to support, and you have to ensure they're having the right treatment and consultation. And then of course there's the agenda of, are we going to keep this person? Do we have to find reasonable adjustments? Do we have to create a stay at work plan? So they're things I think you should always be doing anyway. But often we're waiting on the insurer to make a judgment about liability, and that can often take a long period of time, or it can just happen very quickly where there's an acceptance of liability that changes the course of action. I think we always have to be mindful that we have to care about that person because they are an employee, and their insurance obligations should be seen as separate to what you do as a professional organisation assisting this person with a medical condition or psychological condition. But Darren's going to talk about...
Well, I'm not going to talk about workers' compensation because we've got a separate team who specialise in that. But I'll just pass on a quick story to finish off, in that recently I had a matter where there was a very senior executive involved in fraud, and that caused him to stop working and start sending solicitor letters where we discovered that he had been hospitalised for a psychiatric condition, which he claimed was because of the investigation into his fraud. We said, well, that's all very interesting. However, we have a duty to detect fraud, and it's not part of your ordinary course of employment to be defrauding us. And the fact that you have a psychiatric condition is something that we were reassured was being managed by a hospital. And so the solicitor on the other side was trying to stop us from terminating the employment because it was alleged that it would exacerbate an existing condition. In the end, it was decided to terminate the employment, but through the solicitor, the message was passed that, look, because that person has the best care available in the hospital with treating professionals, we'll leave it up to those people to decide when and how they communicate this decision. And the duty's on you as a solicitor to make those decisions, not us, because we've already decided to terminate. So luckily that solicitor had accepted service, so we could serve a termination letter on that person. But from our point of view, the duty was clear. We had the injury was not caused by us; it was caused by that person defrauding us, and there was the risk mitigation was actually something that was already being treated. So that was our solution to that, and whether or not there was workers' compensation involved was something separate again.
All right, so we might leave it there. I have some closing remarks for the webcast. Thank you for joining us today. The presentation will be available after the end of today's webcast. You'll be able to watch on demand by clicking on the link that brought you to the program. If you'd like to share the presentation with your colleagues, please click on the envelope icon below me and you can forward the presentation link via email. You can continue to ask questions. All the questions that we haven't answered, I'll go through and respond to those questions. There were a lot of questions about what to call an ex gratia payment, so you've resolved that, Darren. Otherwise, thank you very much for your attendance, and we hope to see you next time.
Yeah, thank you very much.